Good afternoon, everyone, and welcome to the 2024 Seacrest Wardle Premises Liability Webinar Series. My name is Sterrett, and I am a partner in our Troy office. Today, we will be discussing the issue of notice. In terms of defining notice and duty, Michigan follows the Restatement of Torts. Specifically, Section 343 states, "A possessor of land is subject to liability for physical harm caused to his or her invitees by a condition on the land if, but only if, he or she knows or by the exercise of reasonable care would discover the condition and should realize that it involves an unreasonable risk of harm to such invitees, and B, should expect they will not discover or realize the danger or will fail to protect themselves against it, and C, fails to exercise reasonable care to protect themselves against the danger." Secondly, the Restatement of Torts also provides that a possessor of land is not liable to his invitees for physical harm caused by any activity or condition on the land whose danger is known or obvious to them, unless the possessor should anticipate the harm despite such knowledge or obviousness. The level of duty owed to those who come upon one's land is triggered by an individual's status as either an invitee, a licensee, or a trespasser. So, who is considered an invitee? Invitees can either be a public invitee or a business visitor. A public invitee is a person who is invited to enter or remain on land for a purpose for which the land is held open to the public. A business visitor is a person who is invited to enter and remain on the land for a purpose directly or indirectly connected with business dealings. For example, invitees can include guests at restaurant and businesses or a tenant at an apartment complex. Invitees are given the highest level of protection under the law and are owed the following duties: a duty to inspect, a duty to warn, and a duty to protect and make the premises safe. Licensees are most commonly thought of as social guests. For example, a friend that you invite over to your home. A landowner has a duty to warn licensees of dangerous conditions on the land of which the owner knows or has reason to know if the licensee does not know or have reason to know of the condition. A landowner does not owe a licensee a duty to inspect the premises or to make the premises safe. Importantly, the only duty owed to a licensee is a duty to warn. This is a lesser standard than that which we see if we're looking at an invitee. The third status an individual can hold on land is that of a trespasser. In general, very little duty is owed to adults who enter another's land without permission. Landowners have no duty to trespassers to notify them of any dangerous condition on the land. However, landowners may not actively injure trespassers in an effort to keep them off their property. For example, landowners are not permitted to set hidden traps, covered pits, or utilize spring-loaded guns to keep trespassers away. It's also important to note that there's an exception to the above rule when it comes to children. Landowners do owe a duty to child trespassers if the condition is considered an attractive nuisance. A possessor of land will be subject to liability for physical harm to a child trespasser caused by an artificial condition on the land if the below 5 conditions are met. First, the place where the condition exists is one upon which the possessor knows or has reason to know that children are likely to trespass. Second, the condition is one which the possessor knows or has reason to know of, and which he realizes or should realize will involve an unreasonable risk of death or serious bodily injury to a child. Third, the children, because of their youth, do not discover the condition or realize the risk involved in meddling with it. Fourth, the utility to the possessor of maintaining the condition and the burden of eliminating the danger are outweighed by the risk to the children involved. And lastly, the possessor fails to exercise reasonable care to eliminate the danger or to protect the children. All 5 conditions must be met for liability to attach. It should also be noted that although the plain language of the attractive nuisance doctrine indicates that it only applies to child trespassers, the Court of Appeals has held that child invitees fall within the category of children protected under the attractive nuisance doctrine. So what is an example of an attractive nuisance? In Brine versus Schneider's Iron and Metal, the court found that a sand pit at a construction site where the landowners responsible for the site knew children liked to play could be considered an attractive nuisance. Attractive nuisance cases are extremely fact-oriented. The defendant's knowledge is a necessary key to these cases. If a child trespasser is injured and defendants generally know of children trespassing on their property for a certain purpose, they may be held liable depending on the type of condition which is involved. Courts have also focused on the actions of the child and if he or she actually had a significant role in the condition becoming dangerous when looking at a case that deals with an attractive nuisance. So let's look at some common situations where a duty is owed by a landowner to a business invitee. The first is items on floors or aisles or conditions of a store. These cases are commonly seen in the premises liability context. It is the duty of a storekeeper to provide reasonably safe aisles for customers, and he is liable for injury resulting from an unsafe condition either caused by the negligence of himself or his employees, or where the condition is known to the storekeeper or has existed for a sufficient length of time that the storekeeper should have knowledge of it. For example, a store owner may be found liable for failing to timely clean up a spill in an aisleway of which they are aware or should have been aware. Some examples of cases where defendants were found to have no notice of an alleged hazardous condition include Whitmore versus Sears Roebuck and Company, where the plaintiff fell on an oily substance in the parking lot of defendant's store. However, there was no evidence that the oil spill came from the active negligence of the defendant's employees or that the oil was in the parking lot for a considerable length of time to infer notice. In Lloyd versus TSFR Apple Venture, plaintiff was a patron at an Applebee's restaurant. On her way back from the restroom, she slipped and fell on a tiled area of flooring in front of the kitchen. After her fall, she claims that she noticed an oily residue on her hands and knees and contended that defendant knew or should have been aware of the condition of the floor and failed to properly maintain the premises. The trial court granted summary disposition in favor of defendant upon concluding that plaintiff failed to establish a genuine question of fact whether defendant had notice or created the condition. On appeal, the appellate court held that a plaintiff must present evidence that the hazard existed for a sufficient length of time and that a reasonable premises owner would have discovered the alleged danger in order to succeed on their claim. The plaintiff failed to meet this burden, and the appellate court found it speculative to deduce that defendant was responsible for placing grease on the floor or should have been on notice of any grease or oil near the kitchen. Another common situation that we see in premises liability cases is that in which a plaintiff has allegedly fallen on snow or ice. So the first thing to note is that a business invitor is required to take reasonable measures within a reasonable amount of time of the accumulation of ice and snow to diminish the hazard of injury to an invitee. A plaintiff's claim may survive if they can demonstrate that the possessor of land had actual or constructive notice of the ice or snow. However, there are multiple cases in which plaintiffs have failed to establish constructive notice of icy conditions. For example, in Durbabian, the court found a lack of notice where 1. It had not snowed for several days before plaintiff's injury, 2. It had only rained for a few hours before reverting to freezing temperatures, 3. The ice patch was only the size of 2 parking spaces, and 4. No other person, including plaintiff, had observed the ice before her fall. Another situation that occasionally arises in premises liability cases has to do with the criminal acts of third parties. This will be discussed extensively in another part of this webinar series. Briefly, merchants have no obligation to anticipate the criminal acts of third parties and are not obligated to do anything more than reasonably expedite the involvement of police once criminal activity has become apparent. And the seminal case on that is McDonald versus PKT Inc., decided by the Michigan Supreme Court in 2001. For example, in Zabremski versus Bedrock Management, plaintiff was attacked in the lobby of the office building where she worked by a woman named Carolyn Winfrey. Miss Winfrey had attacked another employee in the same building 3 months earlier. Following the attack, plaintiff sued defendant, who owned the building and provided security services through a contractor. Plaintiff alleged that Bedrock Management breached a duty of care owed to her as a tenant in the building. The trial court granted summary disposition in favor of defendant, finding that it did not have a duty to anticipate, prevent, or protect against the criminal acts of third parties, even if there had been a similar attack against another person in the past. Further, the defendant had fulfilled its limited duty of care to promptly notify the police after plaintiff was attacked. The Court of Appeals affirmed the trial court's decision in this case. So what are some issues that businesses should focus on when dealing with potentially dangerous conditions on the premises? The first key issue is to decide what condition is involved. Secondly, did the store owner or store employees cause the condition or contribute to it? If not, did the store owner or employees know of the condition? When did the condition form? How long did it exist for? Should the store owner or employees have known of the condition? In other words, is this a condition that occurs quite often, or is this a one-time thing on the premises? Number 8, who or what caused the condition to form? And lastly, when did the property or premises owner become aware of the condition? So what are some of the best practices for businesses when it comes to dealing with these types of claims? It's really important to document the following if possible. How the condition came to be. Did it arise from the defendant's actions or those of a third party? When did the condition begin and when did it end? Also important to photograph the area if possible. What did the condition of the premises look like at the time of plaintiff's injury? When was the area initially inspected? Do you do routine inspections in this area? Also important when we eventually end up having to litigate these cases are reporting. So that could be either by the customer, the employee, did they fill out any type of incident report forms? These are all things that businesses should gather, and they will certainly be important further in litigation. And lastly, try if possible to document the people and witnesses who were there at the time of plaintiff's fall. And that includes obtaining not only names, but addresses and phone numbers if available. Let's now take a look at some of the key decisions and developments in premises liability law as it relates to the issues of actual and constructive notice. Of note, constructive notice arises not only from the passage of time itself, but also from the type of condition involved or from a combination of the two elements. In Lowry versus LMPJ Inc., the Michigan Supreme Court case from 2016, the plaintiff was a restaurant patron who slipped and fell while descending wet stairs. She filed a premises liability action against the operator of the restaurant, which moved for summary disposition. The trial court granted defendant's motion, but the Court of Appeals overturned the decision, ultimately holding that defendant failed to present evidence that it lacked notice of the hazardous condition. Reversing the appellate court, the Michigan Supreme Court held defendant was entitled to summary disposition as the premises possessor did not have to present evidence that it lacked notice of a hazardous condition. The defendant only needed to show that plaintiff presented insufficient proof to establish the notice element of her premises claim. In doing so, the Michigan Supreme Court made clear that a premises owner does not have the additional burden of producing evidence to disprove plaintiff's claims. Notably, where there is sufficient evidence that the premises owner caused the condition on the land, a plaintiff need not prove notice. In Pugno versus Blue Harvest Farms, the court reaffirmed that where the possessor is the one who created the condition, knowledge of the condition is imputed to the possessor. But where the condition is created by a third person, there is a factual question regarding whether the possessor should have reasonably discovered the condition. Constructive notice is based on the amount of time the condition is present on the premises and can be proven with direct or circumstantial evidence. For example, in Priester versus Bell, the plaintiff allegedly fell because of a loose front porch step at a home she leased from defendant. She sued the defendant alleging breach of duties owed under common law as well as MCL 554139. Defendant filed a motion for summary disposition, arguing that she had no notice of the alleged dangerous condition and in fact had inspected the steps on 2 occasions before plaintiff's fall, and they appeared to be in good condition. The trial court granted defendant's motion, holding that defendant did not have notice of the alleged hazardous condition and made reasonable inspection of the premises. On appeal, the plaintiff contended that a jury could infer the defective step was improperly affixed to the front porch, thereby creating a genuine issue of material fact. Ultimately, the appellate court disagreed and upheld the trial court's decision to grant summary disposition in favor of defendant. In Bacon v. Sunshine Products of Mid-Michigan, the plaintiff was visiting a landscaping supply company. As he attempted to leave, he slipped on the store's wooden deck and was injured. He testified that after he slipped, he touched the deck and felt that it was slimy in the area in which he fell. He described the substance as almost invisible and said that he could not see it but could only feel it. The substance did not leave a residue on his hand and seemed to be part of the wood, according to plaintiff. The defendant in that case moved for summary disposition, asserting that it had no notice that the deck was in a defective condition. The trial court granted summary disposition on the basis that nothing indicated the substance was a condition caused by the defendant or that it was there for a sufficient amount of time that defendant would have or should have known about it. In Fagan, the plaintiff drove his car to defendant's clubhouse to pay his apartment rent. He initially walked on the sidewalk without incident, but as he walked back towards his car after paying his rent, he slipped on a patch of ice and fell, resulting in serious injuries. The plaintiff filed suit against defendant alleging negligence in violation of its statutory duties as a landlord under MCL 554139. The plaintiff testified that he was unaware of how long the ice had been on the ground and presented no evidence indicating the length of time the patch of ice had existed. The defendant moved for summary disposition, contending that it had no knowledge of the ice or that the condition was open and obvious. The trial court agreed, and the Court of Appeals ultimately affirmed the decision. In Codra v. Stony Creek Village, the plaintiff left his apartment building to go to work. When he stepped on the sidewalk outside of his apartment, he slipped and fell on ice. The defendant moved for summary disposition, contending that the ice on the sidewalk was open and obvious with no special aspects, and that the sidewalk was fit for its intended use. In a written opinion and order, the trial court found that the ice on defendant's premises was open and obvious, and that although the sidewalk was not fit for its intended use under the relevant statute, there was no evidence that the defendant had actual or constructive notice of the condition. The appellate court agreed with the findings of the trial court and affirmed summary disposition. In Laterno v. Edison Institute, the plaintiff attended holiday nights at Greenfield Village. As she approached the holiday display, she tripped and fell on a curb, fracturing her knee. The plaintiff ultimately filed a premises liability action, contending that the darkness and crowd of people obscured her ability to see the curb. In response, the defendant filed a motion for summary disposition. Ultimately, the trial court granted summary and held that the curb presented an open and obvious condition despite the darkness. The Court of Appeals affirmed the decision of the trial court and further stated that a central element of every negligence claim is that a defendant breached a standard of care. In this case, there was no evidence of negligence committed by the defendant in its care or maintenance of the property. Furthermore, the Court of Appeals found that the defendant had no notice indicating that the curb or the holiday display presented a hazardous condition. In Butler v. Gold Mountain, the court found that the plaintiff had not demonstrated that the defendant had actual or constructive notice of any icy conditions and therefore summary disposition was appropriate. Specifically, there was evidence presented in that case that the ice had historically formed in a certain location on the premises, but that defendant's employees conducted regular inspections and received no other reports or indications of anyone slipping. Further, the employees both testified that they inspected the parking lot on the date of the incident and did not observe any ice in front of the door. The plaintiff presented an affidavit from a safety and human factors consultant, which the court found to be extremely conclusory and providing no explanation of the reasoning underlying the expert's conclusions. The court also noted that an expert's opinion is objectionable where it is based on assumptions that are not in accord with the established facts, particularly where an expert witness's testimony is inconsistent with the testimony of a witness who personally observed an event in question. In another case filed against Kroger, the court found that the plaintiff failed to present any evidence that the defendant possessed actual or constructive notice of a puddle of laundry detergent which plaintiff claimed she slipped on. Factually, the plaintiff claimed that a laundry detergent bottle was dripping onto the floor of defendant's premises. However, the plaintiff failed to provide any evidence regarding how long this particular bottle had been leaking or the rate at which laundry detergent typically drips out of a bottle, aside from her own speculative testimony and a photograph that she took. The court stated that proof as to when the hazardous condition arose was the missing link in plaintiff's case and upheld summary disposition in favor of the defendant. Santos versus Garner Properties is actually a case that I litigated. In that case, the plaintiff sustained injuries when a stair detached from the wall and riser, causing it to shift forward as plaintiff was walking down the stairs. She ultimately lost her balance and fell. The trial court granted our motion for summary disposition, finding that Garner Properties did not have actual or constructive notice of any alleged defect in the stairway. The plaintiff appealed, and the court held that there were no prior complaints about the stairs, which would have given defendant actual or constructive notice of any alleged hazard. The plaintiff had lived in the rental home for approximately 1 year and had never noticed any issues with the step, nor did any of the other residents ever complain about any defects. The court also determined that the defect was not apparent until the date of plaintiff's injury and that there was no evidence as to how long the alleged hazardous condition existed. Ultimately, the Court of Appeals concluded that there was no genuine issue of material fact regarding whether the defect was of such a character or existed for a sufficient length of time such that my client should have known of its presence. The Court of Appeals ultimately affirmed summary disposition in favor of Garner Properties. In Krosky, the plaintiff contended that she was injured when she fell while descending a set of stairs. Specifically, she testified that she and her co-workers were walking down the stairs when one co-worker stepped on the left side of the stair, causing the metal plate covering the step to flex. The plaintiff subsequently lost her balance and fell. The court held that plaintiff's claim of constructive notice failed because plaintiff provided no evidence of any accidents, incident reports, complaints, or maintenance records related to the alleged defective stair. And this goes back to what we were talking about earlier in terms of making sure to document any prior complaints, issues, any incidents where someone has complained about any type of hazardous condition on the property. In Krosky, the court also noted that the plaintiff failed to provide any evidence as to how long the defect existed such that it could be inferred that defendant should have known of the condition. Summary disposition in favor of the defendant was ultimately upheld. In Carter versus Meyer, the plaintiff testified that he fell as a result of a broken soap dispenser which was leaking clear soap onto the floor. The trial court concluded that there were no issues of material fact on the issue of notice and affirmed the trial court's holding, finding that plaintiff did not provide any evidence that soap or another slippery substance had been on the floor for a sufficient length of time such that defendant should have known of its existence. In Cherney versus General Motors, the plaintiff fell after becoming entangled in a pallet strap while walking through a warehouse. The court found that General Motors lacked actual or constructive notice of the alleged hazardous condition because there was no evidence that GM was actually aware of the presence of the pallet strap before plaintiff's fall. The court also noted that there was no evidence as to exactly how long the strap had been lying across the aisleway, but that it had been less than 24 hours from when the pallet was delivered the day before. Given the size of the warehouse, which was approximately 1.3 million square feet, and the limited hours of operation, there was no indication that defendant had constructive notice of the alleged hazardous condition. In Smith versus Empire Property Investments, the plaintiff was visiting her daughter at a rental property when she walked out onto the back porch and fell into a hole. The defendant had purchased the home in March of 2018 and had been relying on a prior home inspection which had been completed before her purchase in January of 2018. The plaintiff argued that defendant had constructive notice of the hazard through its agent, who had been in the backyard twice before plaintiff's fall. She also argued that the size and visibility of the hole would have given the agent notice of its existence. The court found that the defendant had no reason to suspect a defect in the porch given that the home passed a prior inspection. The court also noted that the tenant had never noticed a hole in the porch and had never reported any issues prior to the fall. In Narlock, the plaintiff slipped and fell on black ice on defendant's front porch. 2 days prior to plaintiff's fall, the area had experienced significant snowfall. The defendant's caretaker arrived at plaintiff's home the morning of plaintiff's fall, shoveled the snow, and salted the driveway and the front porch. The plaintiff arrived approximately 5 hours later and fell. The court held that there was insufficient evidence to establish that the defendant had actual or constructive notice of the black ice. Specifically, the court reasoned that the possibility that ice can form is not the same as knowing about the existence of black ice. Additionally, the plaintiff's speculation that the ice may have formed from water leaking from a gutter was an unproven theory. In Whitaker v. Meyer, the plaintiff had rounded a corner to enter a different aisle and slipped on an unidentified liquid. The trial court denied defendant's motion for summary disposition and held that the nature of the liquid was such that a reasonable trier of fact could find that defendant had constructive notice of the condition. Significantly, the Court of Appeals reversed the trial court and held that there was insufficient evidence to establish how long the spill had been present. The Court of Appeals also noted that it could not be established that frequent inspections would or should have uncovered the spill in the absence of any evidence as to how long the condition existed. Something that businesses and our clients should be aware of when litigating these cases is that the temporal component to establishing notice is crucial to the outcome of the claim. In Graybill, the plaintiff stepped outside onto the tavern's patio in the evening to smoke. When she began to walk back inside, the lights which illuminated the patio and the steps into the tavern suddenly went out, leaving the plaintiff in sheer darkness. In reviewing the case, the Court of Appeals noted that plaintiff testified that she was able to observe the steps until the lights went out and had no idea what caused the lights to suddenly go off. Further, although the light switch was inside by the bar, there was no testimony from anyone in that case which suggested that the lights were knowingly turned off. In short, the court found that there was nothing which suggested that the tavern knew or caused the lights to go out. Rather, the plaintiff's fall on the steps was merely simultaneous to the sudden blackout, and no liability was attributed to the defendant. The key takeaway from this case is that evidence regarding how long the defect existed is required in order to prove notice. Also, a failure to discover a defect may not always equate to active negligence. Similarly, in DeClark, the plaintiff fell down 2 steps of a staircase leading to the front entrance of the defendant's office building. It was a sunny day and the stairs were undoubtedly visible. The plaintiff and her husband walked up the staircase without noticing any issues when they entered the building. Their appointment lasted approximately an hour, and on the way out, the plaintiff fell. The defendant filed a motion for summary disposition based upon the open and obvious defense and alternatively lack of notice. In opposing defendant's motion, plaintiff pro-offered a report from an inspector who opined that there were gaps in separation in the steps that could cause injury. However, the panel construed this report to say that the gaps in separation referred to the stairs separating from the underlying brickwork and not where the plaintiff had fallen. Moreover, the Court of Appeals found that this inspection was performed too long after the accident to have much probative value. Additionally, neither side's photographs revealed anything that, in the panel's view, was suggestive of a defect or hazard. Summary disposition was therefore warranted because there was no evidence that any defect in the steps had existed for long enough or was of such a character that the defendant should, by exercising reasonable care, have discovered it. In discussing these cases, it's important to keep in mind that in general, constructive notice will not be found where the defect is latent, i.e., of a nature that it would not be discoverable upon casual inspection. The failure to make a diligent inspection may constitute negligence, but only if such inspection would have disclosed the defect in the first place. The issue of a latent defect was explored in Davies v. Sheets, which is an unpublished opinion of the Court of Appeals issued in September 2015. In that case, the plaintiff was injured when a patio he was standing on collapsed. The defendant obtained summary disposition based on the fact that a casual inspection would not have revealed the damage to the foundation that ultimately resulted in the collapse. The court cited the plaintiff's testimony that neither he nor his girlfriend noticed anything wrong with the patio, and also noted that the plaintiff failed to present any evidence that a casual inspection would have uncovered the underlying foundation issues. The final issue that I would like to discuss with you today is the causation element in premises liability cases. Michigan courts have repeatedly rejected claims of landowner negligence where the plaintiff cannot demonstrate the cause of the injury. The courts have held that a plaintiff must present evidence linking a specific defect or condition on the premises to the injury-producing event. Mere speculation and conjecture is insufficient. Furthermore, the mere occurrence of an accident in and of itself is not sufficient to establish a genuine issue as to factual causation. Several unpublished cases from the Michigan Court of Appeals have addressed this issue. The two cases you see on the screen are simply examples of this. In Adams, the plaintiff suffered an injury when she slipped and fell on a step in defendant's restaurant. The plaintiff testified that she lost her footing on something slick like ice or grease. However, she failed to identify the presence of grease or any other foreign substance on the step where she fell. Because the suggestion of grease on the step was entirely speculative, no fact question was created. In reaching its decision, the court noted that in opposing a motion for summary disposition, a party cannot establish a question of fact through conjecture or speculation. In Jones v. Carter Food Center, a customer in defendant's store tripped and fell when her foot caught on a bunched-up rubber-backed rug that she had pushed her shopping cart over. Plaintiff's complaint alleged that the rug was old and unraveling and that defendant knew or should have known of its unsafe condition. The Court of Appeals affirmed the trial court's ruling granting defendant's motion for summary disposition based upon its finding that plaintiff failed to present evidence concerning the age of the rug or whether its age or condition contributed to plaintiff's fall. Thank you for attending this webinar on notice, knowing what was wrong. Please feel free to reach out with any questions you may have.